Welcome to this week's edition of World Crisis Radio. And as a result of a legal action brought against me by Melania Trump, and therefore I think by the Trump campaign, it now falls to me to fulfill the role of your First Amendment champion. Right now we have an unprecedented lawsuit against the London Daily Mail and against your humble servant. And that is a lawsuit brought by in effect, by a presidential campaign against, in one case, a large newspaper, one of the London tabloids, and on the other hand, against myself. I am an independent blogger. I am a person of, we could say, modest means. I am not a billionaire, but nevertheless, it seems now to be my job to assert the First Amendment. And I want to say something, first of all, about why I think this is so important. And I have to make no bones that I'm asking for people's help. I'm asking you to support me in the course of this action, because the only conceivable way of opposing a very oppressive and chilling kind of legal action is for the people who support the First Amendment. Please stand up. Please do some things. Be active. Support me in any way that you can. Now, I cannot obviously go into the internal details of this lawsuit because this may get to litigation. I'm not going to comment on any of that, except from the outside, not going inside, but staying outside. It is, in my view, unprecedented. My research is not yet complete. But as far as I can see, it is unprecedented for a presidential candidate's wife, an aspiring first lady, to come forward and sue a journalist in this country, or indeed a foreign newspaper. I don't see any precedent for it. And I would remind you that the question of the first lady, well, as soon as you say First Lady and what the rules are for First Lady, I think you have to look at Hillary Clinton between 1993 and 2001 and look at all the charges and criticisms that were leveled against Hillary Clinton as a First Lady. And this was done with no holds barred. This was an extremely vigorous and implacable campaign of public criticism against Hillary Clinton. And of course, the same went for Bill Clinton. And then you can go on to George W. Bush, and you can even look at some criticism and other negative derogatory information published against Laura Bush. But I think if we hold on to the Hillary example, you will see that this went on without limits. Now, somehow things have changed, and not in a good way. So now we have the danger of some kind of a chilling, a narrowing of the First Amendment. Now, Donald Trump has never made a secret of his desire to limit, to restrict, in my view, to undermine the First Amendment. You may remember that when he appeared to meet with the Washington Post editorial board back in the springtime, he was asked about that. And in particular, one of the members of the editorial board, Ruth Marcus, who's also one of the Washington Post journalists, confronted him saying, in an ideal world, you'd be able to sue me, right? And he said, well, I might be looking for a retraction or a correction, but the idea, yes, a lawsuit. And he also said several times during the Republican debate that we want to tighten the libel laws. And what that means is to restrict free speech as we've known it and make it more easy to sue and otherwise come after people who are doing standard political journalism, right? And again, think of that Clinton era and think of the guideposts and benchmarks established during the time of Hillary Clinton, which was a no-holds-barred approach to this. So something very strange going on. Now, let's just talk about the tremendous benefits of free speech. I don't think I am exaggerating if I say that the First Amendment is at least a pillar and cornerstone of our entire system of government. In some ways, it is the pillar and cornerstone of the entire edifice of our government. And you'll remember what it is, right? It's the First Amendment. It's got precedence over the others, right? That's got to mean something. Congress shall make no law respecting an establishment of religion, and it goes on, or abridging the freedom of speech or of the press. Freedom of speech and freedom of the press. I think both are involved here. So this is essential. In other words, the entire genius of the American form of government is to take conflict and channel it into the various branches of government, the executive, the legislative, and the judiciary, and have that conflict fought out openly but peacefully, with words, with invective, sure, with polemic, and so forth. So it's one of the stabilizing mechanisms of our form of government to have free speech and freedom of the press in this form. That is, I think, a critical public interest. It's part of our stability. It's part of the idea that you don't immediately see conflicts arising in the streets. They can arise in the halls of Congress or in the press or in public meetings or demonstrations. And the entire panoply of what the Supreme Court and others have defined as free speech and freedom of the press. We've had all kinds of conflicts about reporters and their sources. And generally speaking, we have to remember the only profession, the only industry, really, if you want to call it that, mentioned in the Constitution is the press, journalism, being a reporter. So this enjoys a kind of special status under our system of government. Now, the current interpretation from the Supreme Court goes back to the famous case of Sullivan versus New York Times. And out of that that decision, that verdict, right, that precedent, we are reminded that under our system, private persons enjoy greater protections, but that public persons enjoy far less in the way of protections. And the further you go up the ladder and the more public the public person becomes, the fewer the protections. And of course, the presidency, the president, the first lady, the first family, and other officials around them in the White House, those are the most public of public persons. Back in a minute on World Crisis Radio. To World Crisis Show. This is Webster Tarpley. Now, I'm your First Amendment champion. I am the only American named in any of these actions so far, and therefore I urge you to help me fulfill this role and support me in any way you can. And certainly one way to do that, I've been talking about this now for the past 2 or 3 weeks, is the radio broadcast that I now do every day, and it soon will be 5 days a week. The American System. The American System brings together Daniela Walls, of the Tax Wall Street Party, myself, and we do the news day to day, but really hour by hour. We're keeping up with world events. So I would ask you to go to americansystem.tv. That is americansystem.tv, and subscribe. And you will then be kept informed about all of the critical features of this critical legal action. So we've affirmed the absolute necessity of free speech, the absolute necessity of a free press. This is the American tradition. This is the heart of the matter. And at the very pinnacle of the First Amendment, the most public people in this land are the president, the first lady, and other top government officials in Washington. That is where the First Amendment begins. The First Amendment also lives through the efforts of writers, journalists, reporters, bloggers, people like me to some extent, but also big newspapers who attempt to keep the First Amendment flexible and young, and not let it fall into desuetude or neglect. Right? It's got to be exercised, otherwise it might become sclerotic, and that would be a disaster for our country. So again, if you're a public figure, you have a very difficult standard. If you're a public figure and you want to prove that somebody's defaming you, you've got to prove that that person knew that the charge was false or acted with reckless disregard to the truth. And I can, without going into any details, I assure you this does not apply. Now, the other question is, the courts over the years, and rightly so, have granted a great deal of leeway to people writing about political matters and people who are writing about, in particular, the presidency. And the purpose of this is, it's widely recognized that somebody running for president has got to be thoroughly vetted. They've got to be thoroughly examined. They've got to be researched. It's important, as I've always said, if you want to get your hand on the thermonuclear button, then the public has to know everything about you. And by everything, I mean everything. Be it your tax returns, be it your health records, be it your mental health records, and similar information. There really can't be any areas that are off limits if you're running for president. If you want the nuclear launch codes, you're going to have to submit to that kind of an examination. So therefore, it's been recognized as a public interest that there be the most thorough examination, the most complete examination, the most comprehensive examination of people who want to take over the White House. Now, Melania Trump is a public figure. This is beyond the shadow of a doubt. There's a lady who took to the stage of the Republican National Convention in Cleveland, I believe it was July 18th, and she gave what amounted to the keynote address of that Republican National Convention and called in the course of her speech for her husband, Donald Trump, to be elected president of the United States. There is nothing more political. There is no more political terrain for such statements than the one she therefore went on to. So that establishes her as a public figure, and among public figures, one of the most prominent in the entire country. So this unprecedented lawsuit, once again, we'll be looking, right? If we find precedents, we'll call them to your attention. Threatens all of that. Now, let me also point out why I consider this so important. If you have unclarified issues, if you have areas of uncertainty in regard to the first family, in regard to a presidential candidate or an aspiring first lady or a vice president for that matter, people who are going to exercise what is now a supreme power of life and death because of the question of the nuclear arms that we possess and others possess, obviously, that is a grave danger to national security. These issues, if they're unclarified, they must be clarified. If they are uncertain, they must be made transparent. Because otherwise, what might happen? If you have unclarified issues in the first family, then we must assume that foreign intelligence agencies are thoroughly aware of these matters and might use these unclarified areas, these areas of less than transparency. They might use these areas to blackmail the White House, to blackmail the president. And this then impacts the entire national security of the United States. So I think that's a public interest, right? The first is that the First Amendment is the pillar and cornerstone of our entire system of government. And secondly, the question of foreign intelligence agencies blackmailing the First Family and the White House. This cannot be excluded. We've even had former CIA officials speculate about various kinds of influence exercised from abroad on the candidates one way or the other. So I think that is absolutely relevant, absolutely germane, and people should look into it. Now, there's also a question of the international standing of the United States. Let me just point out that in the past, 12 hours, really, there's been an unprecedented expression from the world of interest in this case. And this has included the New York Times, Reuters, NBC News, the Washington Post, various television stations, BuzzFeed, and so forth. So ITN News in Britain today. So great interest, and I'll be back with you in just a minute. This is Webster Tarpley here in Washington, D.C. Now, I am happy and honored to be joined by a wonderful attorney who has given me some important insights into how these things work. It is Jeffrey Jackson of Jackson Associates in Houston, Texas. He is a fighting lawyer, fighting for the people and for the Constitution. He has done yeoman service in the area of consumer rights, but also in particular in fighting off foreclosures and allowing people to stay in their homes. And Jeffrey Jackson is someone who habitually sues Wall Street, money center banks, and prevails, and helps people to maintain their rights and their livelihood. So, welcome, Jeffrey.
Thank you, Webster. Happy to be on the show. My warmest greetings to you.
Okay, so I know you've looked at this complaint, if we can call it that, and maybe you give us your take, and then maybe we go on to some of the broader issues.
Sure. Well, if you're going to look at the complaint itself, it's a very formulaic complaint. I think the complaint is available on several different articles that are showing up today. It is essentially a boilerplate complaint that alleges what the defamatory statements they allege are, and then simply makes the blanket assertion that they have been damaged. There's really nothing much in the complaint that goes any deeper into what they are thinking or how they are thinking. From a broad perspective, though, libel law, defamation law in the United States, you may have already mentioned this in the course of your program, it is geared toward promoting a robust public discussion, particularly about public figures and public figures involved in public office. The seminal case on defamation and where state libel and defamation law meets the First Amendment is in the Sullivan versus New York Times case. And in that particular case, I want to read a quote out. It says that there is a special protection required for the press in order to preserve the profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and that it may well include vehement, caustic, and sometimes unpleasant attacks on government and public officials, but that those are allowed. And the reason for that, going back hundreds of years, obviously, to the founding of our country, is that we are fundamentally a democratic society, and that a democratic society must rely on a robust public discussion in order to function appropriately as the founders intended. That is why when it comes to public figures, and I'll make an aside here that there's no doubt in my mind, and there's no doubt that a Maryland court would also find that Melania Trump is a public figure, and that not only is she vying to be First Lady, which she could have divorced Donald Trump if she really, really didn't want to be First Lady, but she also inserted herself publicly into the Trump campaign by being a keynote speaker at the Republican National Convention. So when it comes to public figures, the burden lies, in this case, on Melania Trump as a public figure to prove not only that you in the Daily Mail were merely negligent, but that you actually had malice, that you did not intend for this to be a part of the public discussion about Melania Trump as First Lady. And I think it's absolutely ludicrous, and it would be nearly impossible. It's going to be nearly impossible for them in this scenario to prove that you acted recklessly or that you acted with actual malice toward Melania Trump. So I'm looking at this lawsuit, the fact that she's a public figure, the fact that they're not going to be able to come up with anything that could actually show that you were reckless or had actual malice, that this is simply, as you stated in your statement that you posted on tarpley.net, a blatant attempt to not only intimidate you, but to intimidate all of the other journalists and bloggers out there into remaining silent when they otherwise would not have when it comes to Donald Trump, Melania Trump, or any other public figure. So I'm not surprised, given Donald Trump's litigious history, that he hired, the same attorney that sued Gawker to sue on behalf of his wife.
Right.
Because Donald Trump has proven to be a very litigious person, as we know, hundreds and hundreds of lawsuits across the country. So I think at the end of the day that it's just another example of not only Donald Trump, but the Trump family in general, that they are willing to bring nearly, in my opinion, frivolous lawsuits like this in order to intimidate the press. And as we know, Donald Trump has made statements in the past, just within the last few months, I believe, saying that if he were president, that he would do everything he could to roll back the journalistic protections of the First Amendment and to increase or to decrease the burden on plaintiffs like Melania Trump to prove libel and defamation. So yes.
What I was saying in the first two segments is that if you look at our entire system of government, right, this is the First Amendment, right? They put it first, and it is the freedom of speech and the freedom of the press, and these shall not be abridged. And that really, I think you can say in some ways the entire system depends on this, because this is the regulator, right? And as has often been pointed out, the only profession mentioned in the Constitution is press. It's reporters, journalists, right? People who do pretty much what I do, although some of them do it on a larger scale. So I would also be interested to see what are the further implications of this. Where does that leave our entire system, right? If we could think about that for a little bit.
Right, right. If you look into the Supreme Court cases, they do a balancing test as part of their analysis. If they take the benefits arising from a robust public discussion and they weigh it against the, possibility or the harm caused by possibly defamatory statements coming out of this robust marketplace of discussion. And without hesitation, every Supreme Court case errs on the side of the robust public discussion. And they talk about how chipping away...
Jeffrey, I wonder, that's our hard break. Can you stay on for the next segment?
Sure.
Wonderful, thank you. We'll be right back here on World Crisis Radio. Webster Tarpley here in Washington, D.C. So we're privileged to have with us Jeffrey Jackson of Houston, Texas. Again, a lawyer fighting on the side of the people, regularly challenging and besting the big money center banks on foreclosure issues. He's done a great deal of work for consumer rights. And again, the main issue is foreclosure and how to avoid it when, of course, it's often it's abused, right? The robo-signers and all that. So, Jeffrey, you were saying that you'd actually reviewed some of the jurisprudence from the Supreme Court, and that whenever in these cases the justices are confronted with the balance of the equities, I guess, between a robust discussion and possible embarrassment to an individual, the overwhelming tendency is to go for the robust discussion. Is that accurate?
Yes, that is absolutely right. And the idea is that even though they take that position to err on the side of a robust discussion, that they acknowledge that taking that position, that it is possible that it could increase the likelihood of embarrassing defamatory statements with regard to public officials. But the Supreme Court says that's all right. And they essentially say that if we were to strengthen the libel laws and weaken the position of the First Amendment, that the impact on the robust discussion would far outweigh any harm that would result from defamatory statements made. And so the idea is that the Supreme Court is willing to give credit to the American people, in other words, that people should get all of the information that is available and out there in the public realm, in the public discussion, and that they can decide for themselves whether something is defamatory, libelous, and disregard it. And so that has essentially been the hallmark or the foundation of the free press in the United States from the very beginning, with the recognition that as we were turning into our own country and separating from Great Britain, that we wanted to be a country with a more robust and free press compared to our predecessors. So the idea is that the burden remains incredibly high for public figures to actually prove in a court of law that they were defamed. And the fact that they sued you and they sued the Daily Mail, surely knowing that Melania Trump is undoubtedly a public figure, tells me that the suit was more likely an attempt at intimidation rather than a lawsuit that they actually think that they can win.
So, in other words, we're talking about the public's right to know. Let me ask you a couple of questions, though. Since you've been doing some historical retrospectives on these cases, I would ask you two things. First of all, are there recent precedents of presidential candidate and spouse and or suing journalists? And the questions that came to mind for me were Hillary Clinton between 1993 and 2001 was the target of an overwhelming barrage of scurrilous and maybe even defamatory material, right? And pictures and all kinds of things. And I'm wondering, did she ever try to have recourse to the courts to suppress that?
Not that I am aware, and I am aware of no recent or even historical precedent with regard to a candidate for president or a candidate for president's wife ever suing under libel or defamation laws. This is, to my knowledge, a first and a pretty scary precedent, in my opinion, when you have a candidate's wife for the highest office in the land suing journalists, months before the election. It's unheard of,
Nice.
and it would set. It has set, because they have sued it, I guess you could say, it has set now a disturbing precedent that candidates can influence an election and the press's coverage of an election by bringing suits like this in the middle of an election. A suit, like I said, that has all the appearances of a design to intimidate journalists who may have otherwise delved deeper into Melania Trump or Donald Trump from actually doing that now. And I don't think there's any question that Melania Trump's past has relevance to the presidential election, because there's all kinds of different ways, something in her past could be used to blackmail Donald Trump as president, for instance, or something like that. So the fact that they've sued has, in my mind, it's put a muzzle on stories that might have otherwise come out, and we may never know now.
Right.
And that's a dangerous precedent.
And when you say blackmail, I mean, that's my starting point has been that. In other words, we've had, in the course of this campaign, we've had a former director of the CIA suggest that one of the candidates is under the influence of a foreign secret intelligence agency. So the foreign secret intelligence agencies are going to know this, and if there is blackmail to be done, we have to assume that they're going to attempt to do that, and that the national security is therefore at stake. And therefore, there is, I think, a significant public interest in not allowing the chilling of free speech and free press on a matter like this.
I couldn't agree more. Being First Lady, being married to the president, matters related to the First Lady, particularly when she has exposed herself by being a keynote speaker at the convention. That there's no question that that is of public interest and relevant to the election. So it is. You've been saying, Webster. I frequently listen to your program. I don't miss very many, and you have been saying that a Donald Trump presidency would be a departure from the American tradition, a complete and utter departure from our Republican system, and by that I mean our democratic republic, not Republican Party.
Right.
And this lawsuit is an example, I believe, or constitutes evidence to support your assertion that Trump is not business as usual. Trump and a Trump candidacy would be a Trump presidency would be a presidency of intimidation and a presidency of authoritarianism.
All right. Perhaps we leave it at that. I don't want to keep you from your well-deserved Labor Day weekend. Want to thank Jeffrey Jackson in Houston, Texas, and express all my gratitude and admiration for the fine work he does. Okay, Jeffrey?
Thank you, Webster. Happy to be on the show.
We'll be in touch. Thank you so much.
Goodbye.
And we'll be right back with World Crisis Radio. So the issue is now the First Amendment, freedom of speech, freedom of the press under unprecedented assault. There are no precedents for this action against yours truly. Let me just take this opportunity to sum up my response. This is the statement which I have issued and which is now circulating, I guess, around the world. Statement regarding Melania Trump lawsuit. Melania Trump's lawsuit against me is without merit. Mrs. Trump is she's a public figure, actively engaged in the Trump for President campaign. We are confident that Mrs. Trump will not be able to meet her high burden of proving that the statements published about her on my website are defamatory or were defamatory in any way. Her lawsuit is a blatant attempt to intimidate not only me, but journalists of all stripes into remaining silent with regard to public figures. This lawsuit is a direct affront to First Amendment principles and to free speech in our democratic society. Signed, Webster Tarpley, Ph.D., dated yesterday, September 1st, 2016. Now, let's talk to some people who may not care much for me, but whom I would appeal to take this very seriously and see that in some ways I'm acting on your behalf. In other words, the crushing of me gets you nothing. It's going to get you a lot of grief down the road, because once these precedents are there, they're there. For example, the libertarians who care about liberty and who care about the Constitution, as they've often said. Well, I know that in many cases your interest goes to the Second Amendment, which you regard as the cornerstone of liberty and freedom. And I, as people I think know, I don't propose any action in the area of gun control. Right? I say leave it alone for the moment, because it's impossible to do anything because there's no majority to move in any direction of that. There are a couple of things one can do, right? That psychotic individuals should probably not have firearms, but beyond that, nothing. So I have not damaged your cause. I have studiously avoided that issue. And therefore I say to you, you have to be concerned about the First Amendment as it is at stake in this action against me. and this, I think, ought to go beyond a political loyalty to a candidate towards the needs of the country, the key parts of the Constitution. Again, journalism, the only or press, the only function, economic function, essentially mentioned in the Constitution, and then that question of free speech and free press right there at the beginning with the most fundamental of all freedoms. So, Second Amendment, if you want to organize to protect the Second Amendment, you're going to need the First Amendment in order to do it. You're going to need to write about it, and you're going to need to talk about it, and indeed you're going to need to rally about it, right? You're going to have to assemble peaceably and petition the government for redress of grievances if it comes to that. So without the First Amendment, no political action worthy of the name is possible. Libertarians say they want to be free. Well, help me to defend that freedom. I urge you, I appeal to you, because again, once these precedents have been racked up, they are pesky and they stay around, and it's a very important thing to act in a timely way, right? As the lawyers all say, if you don't assert your rights in a timely way, you have waived them. And the First Amendment, I say to fellow journalists and people who work in the media of any kind, all across the spectrum, the First Amendment lives through us, and it is indispensable in some ways to push the envelope. In other words, to make sure that the First Amendment remains vibrant and flexible and up to date, and does not become sclerotic and frozen and creaky and neglected. It's got to be used. It's like your legs. You don't want arthritis to overtake the First Amendment, because then, believe me, we are in very bad shape as a country. So I'm appealing to people, go to my website. Go to americansystem.tv, americansystem.tv. It's all lowercase, no spaces, nothing in between, all small, americansystem.tv, and subscribe. Become a subscriber to the American System daily radio program, which goes out. Daniela Walls is part of it every day. I'm there, and we keep up with the daily news. Right? We've gotten a lot of requests from people saying, "I would love to follow you day by day, but you've got to be on the radio day by day." Well, right now we're on radio a total of 5 days a week, and soon that will become 6 days a week. So that will be the question now after Labor Day, and it means next week. So I hope people will take all of that very, very seriously. So take that statement and indeed send it around, please. What else can we now mention? Let's see. Let's talk about some related issues. Actually, let's talk about some historical issues. I'm always for those. The background for all this, right? These kinds of turbulences that we see in our world, this has a lot to do with the fact that we're living through this party realignment, right? The breakup of the parties. And I guess we can actually talk about 4 American parties which have come and gone over the history of the Republic, right? Say since 1788 and the coming of the George Washington administration. We had the Federalists, who disappeared along the way. We have the Whig Party, who also disappeared along the way. We probably ought to say something about the Anti-Masonic Party, which was a rather interesting political formation. It got support from all kinds of people. Thaddeus Stevens, the later radical Republican leader, you've seen him in the movie. But also John Quincy Adams, I think, had some good things to say about the Anti-Masonic Party. And then we have the Know Nothing Party, and I think the Know Nothing Party allows us to answer the question: who are the nationalists today? Who are the American nationalists? Is it Trump, or is it somebody else? Let's talk about that. And then we probably ought to say something about the history, say, in the time when the collapsing know-nothings were confronted by the growing Free Soil and then Republican parties. So we'll be back in a minute on World Crisis Radio. This is Webster Tarpley speaking from Washington, D.C. We're now on the verge of the Labor Day weekend. Let's just look at this question, right? The entire framework for our time is the idea of the party realignment, right? We had the New Deal party system dominated by the Franklin D. Roosevelt New Deal Democrats, 1932 to 1968. Then with the Nixon-Strom Thurmond deal, the Republican Southern strategy, the parties flip, especially in the southern states. The Republicans become the party of racial discrimination, but dominate the White House, given this huge Southern voting bloc. And now there are inroads into the Southern voting bloc. That Virginia seems to have gone over to the modern-day Democrats, North Carolina on the verge, Georgia in play, Missouri in play for a while, and so forth. And we have also got to realize the model, we should always stress, the model for what might well now happen to the United States. California. And in California, in large parts of the state and overall, the Republican Party is virtually extinct. Their ability to block legislation, to sabotage the functioning of government, to impose their will, be it through voter ID, we'll talk about in a minute, they just don't have that anymore. And now with that jungle primary where the two top vote getters go, I think we're going to have a Senate contest with two Democrats facing off for the United States Senate. The Republicans are just out of the picture. California, so often showing the rest of the country its future. I think they're doing that now. I think they have been doing it. And it goes back to the world of Governor Pete Wilson of California, who essentially staked out a position of implacable hostility to Latinos and to immigrants in that state where that is such a demographic absurdity. He went ahead and did it, and the Republican Party has been reeling ever since. But now let's just talk about these parties, right? The parties come and go. The Republican Party, we believe, is on its way to oblivion, at least as a national political force capable of sabotaging government, of shutting down the government. And we've been talking about that lately because, of course, people want to know, why didn't the economy recover? Well, the economy didn't recover because of Wall Street, because of the fact that the reform legislation, right, the various palliatives, right, the various Band-Aids that were offered, right, Dodd-Frank above all, this impotent piece of legislation. Dodd-Frank didn't work. The zombie bankers in Wall Street have racked up more and more derivatives, and they are now set to take part in a European banking crisis. Then on the other side, though, we had all this stuff with the Satan Sandwich, the Super Committee, the Fiscal Cliff, and all of the sequestration, this draconian austerity, which is now crippling our entire government like a straitjacket, like a ball and chain. And then, with the help of Cruz and other Republican fanatics, the October 2013 budget crisis and the shutdown of the United States government. And in the course of all that, there were two close calls on default, on national bankruptcy. So those are some of the reasons, right, that Standard & Poor's was offered a pretext, an engraved invitation by the Republican Party to downgrade U.S. debt and thereby increase the interest rates that the U.S. government pays. I don't think it worked, but it may work again in the future. All right. So Republicans on the riding off into the sunset, we hope. The Federalist Party was, of course, the glorious party of Washington and Hamilton and of John Adams. Maybe it's unfair to say George Washington was a part of it, but in fact he was, because he always sided with Hamilton when push came to shove. So the Hamilton Party, the Federalists, and the Jeffersonians, the Democratic Republicans, or whatever they called themselves along the way. After Adams, it was impossible for the Federalists to elect a president, right? They just couldn't do it. So the Jeffersonian Virginia dynasty came in, Jefferson, Madison, Monroe, and so forth. How did the Federalists then meet their demise? Well, the problem was, during the War of 1812, all of the healthy forces, be it Henry Clay, or I think even the young, Henry Clay, certainly, and that entire group later became the Whig Party. The War Hawks of 1812 said, if we don't assert our independence against the British through military means, we're going to wither on the vine, and we're going to essentially fall victim to the British death watch. The War of 1812 went very badly because Albert Gallatin had made sure that Jefferson and so forth did not provide an adequate army and navy, so the U.S. was racking up huge defeats, debacle after debacle, and that then became an overwhelming problem. The other issue, though, was that since the British were blockading American commerce, it was the New England states, the Boston area, most dependent on foreign trade, that began to express defeatism. Federalist Party died of defeatism and secessionism. And the secessionism came forward at the Hartford Convention of December 1814, where the Federalists said they were going to send ambassadors, as they called them, to Washington to try to negotiate God knows what. By the time they got there, the war was essentially over, and I think the news of Jackson's victory at New Orleans had already reached Washington, D.C., so it left the Federalists as a party of rich people. They had, of course, degenerated since the days of Hamilton. This really was the plutocrat party because, of course, Hamilton had been dead for almost 15 years by this point, or something like that. So at that point, the Federalist Party became extinct, and their last attempts at some kind of office were between 1816 and 1820. And the fact that they were gone opened the door to the era of good feelings, when there were practically no parties. Now, I don't anticipate in our time an era of good feelings, although at least a certain lessening of the acrimony might be possible. Anyway, Federalists died of secessionism and died of defeatism. We'll be back in a minute on Old Crisis Radio. So we just talked about the extinction of the Federalist Party around 1816, 1820. It was all over. And then the era of good feelings. Now, the Whig Party, let's talk about them. The Whig Party emerged in 1828 when King Andrew took over the government. That was the angriest candidate we've seen up to now, probably losing his place, though, today. Andrew Jackson, Freemason and angry. And, he immediately elicited a backlash, which was called the Whig Party. Now, you can see what the problem with that is. The Whigs are simply the anti-Jackson party. So it's kind of a catch-all. It's a potpourri of different kinds of political factions. And there were northern industrialists or fairly modern people, and there were southern slaveholders and slaveocrats who were in it. The organized incompatibility, as it was called, right? In other words, they just couldn't agree on anything. And remember the victories that they had in the 1828 to 1860 cycle. The exceptions were a couple of Whig victors, Benjamin Harrison, 1840, Tippecanoe and Tyler too, and then Zachary Taylor in the 1850s, great hero of the Mexican War. So you get the idea. The way that it broke up, how can we say, died of slavery and also died of immigration in a very interesting and sort of bizarre way. As we know, there was the sectional issue over slavery, right? And the main Southern issue was not states' rights, but slavery. And if it was states' rights, it was the state's right to hold slavery. So in the last attempt of Henry Clay, trying to buy time, hoping that conditions would improve, hoping that civil war and secessionism could be avoided, Henry Clay engineered the Compromise of 1850. This is the so-called Kansas-Nebraska Act, and it led to then constant fighting in Kansas, a civil war starting in Kansas, known as Bleeding Kansas. I wonder what that tells us today about the Koch plantation in Kansas, where the draconian austerity, the tax cutting demanded by the Koch brothers and others has essentially crippled the state of Kansas. And it seems to go on into Oklahoma too. Very, very great crisis there. Anyway, the Compromise of 1850, various things that were in it. The thing that was most controversial was the Fugitive Slave Act. So the Fugitive Slave Act was that the northern states, all states, were forced to tolerate or participate in the rounding up of escaped slaves, even though they didn't want to do it. And if it comes to states' rights, some of those northern states said, well, we're going to pass personal liberty laws. We're exercising our state's right against slavery. And the proto-Confederates said, no, 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 you can't do that. The only way you can have states' rights is if you do it in favor of slavery. So this is the kind of split that they have. At their convention, and I think this is 1852, the platform said that the party was fine with slavery, but the candidate said, no, I'm not fine. I don't want slavery. I don't like it. That is General Winfield Scott, a hero of various U.S. wars, Winfield Scott, and he's the candidate they had for president. So the party was split. It's sort of what we have today, right? Some people say, I'm voting for Trump, but I'm not going to endorse him, or I'm going to endorse him, but not whatever it is. Senator Ayotte of New Hampshire has contorted herself on this issue. So the platform and the candidates split. Now, the thing that actually set it off, though, given all this as the real causes, that Scott made a play for the Irish vote at a time when xenophobic backlash and know-nothingism were in the air. And at some of Scott's rallies, he would have an Irishman ask him a question, and Scott would say, I'm so happy to hear that rich Irish brogue. In other words, I'm happy to hear the dialect of Ireland. And he was much criticized. I mean, that was put out by the Democrats, by the Jacksonians, and it then led to a split of the Whig Party. Right, that some of the leaders were for the Kansas-Nebraska Compromise of 1850, and some of them were against it. So they could not come up with a position. Right, what we have today, flailing, no position. And according to some historians, the Whigs by 1852 were too moribund, too weak to have a clear position on anything and force it through. Okay, so Whig Party died of slavery, died of inability to agree on anything, and then this little detonator, this thing about the rich Irish brogue. Now, in the 1850s, and this is between 1852 as the Whigs are collapsing in 1854, 56, you have the rise of the Know-Nothing Party, the so-called Native American Party. And I would submit, you go back to 1856 or thereabouts, You have the Know Nothing Party, where it's Millard Fillmore, former president, is the candidate in 1856 for the Know Nothing Party. But here you have a choice. You can either be xenophobic with the Know Nothing Party, the Native American Party, or you can be an American nationalist with the Republican Party, right? And that would have been John C. Fremont, 1856, who did not win, but he set the stage for Lincoln. So get the idea? The xenophobic party is not, repeat, not the National Party. The Republican Party of Lincoln in the future, but at this point with Fremont, that's the nationalist party. Anyway, the Know Nothings had no answers on slavery, secession, so they essentially disappeared and they were swept aside by Lincoln. Although it does mean that some of the people in the Republican Party of 1860 and so forth were originally coming from the Know Nothings. The other thing I would point to, which was that there was this Anti-Masonic Party. And this was, on the surface, this was the American system. It was supported by Thad Stevens, Gettysburg College, and John Quincy Adams. And the target, this was another way to be against Jackson, because Jackson was a notorious Freemason. So in this case, the Freemasons were just, again, pushed aside by the growing momentum for the Republican Party in 1856 and then in 1860. So the extinction of parties and how this works, and what I hope you got out of that brief and necessarily sort of elliptical summary, some of the signs of the creaking and the wrenching and the rivets popping in political systems when they're on their last legs, and also that this can sometimes be a time of upheaval. Now, let's look forward to the congressional session that's coming next week. Or first of all, let's look forward to the presidential election. I think one encouraging sign that in the near future, we will bring you a discussion of the really deep roots of freedom of speech and freedom from the press. And I want you to know that one of the starting points for this is John Peter Zenger in little old New York. In New York in the year 1734, where the royal governor put Zenger on trial for criminal libel after the publication of satiric attacks. This was the New York Weekly Journal. He criticized the colonial government, William Cosby, oh my God, and was arrested. The grand jury refused to indict him, and he was then charged by the attorney general, but he defeated these charges. And it used to be that in Federal Hall, right, with George Washington on the steps, right across from the stock exchange, they had an interesting exhibit about Peter Zenger, and there's a Zenger room here at the National Press Club. All right, 2 words on this Trump immigration speech. Right, we're trying to parse it. There are 2 theories. One theory comes from Lawrence O'Donnell on MSNBC, and he says that that the tone and the theatrics of this speech are hard line. So that would be the 360-degree turn. In other words, the softening has been banished from tone and tint, but he says there is still a significant softening, essentially an escape hatch through which you can drive whole continents and whole planets. And it is this line, this is Trump talking now, quote, "And the establishment of our new lawful immigration system, then and only then, once you've kicked out all the criminals, you've reached your deportation goals, you've ended illegal immigration, create the wall in record time at reasonable cost. There's a waffle there. Reasonable cost. What does that mean? Who's paying? Not clear. But the establishment of our new lawful immigration system, then and only then will we be in a position to consider the appropriate disposition of those individuals who remain. The appropriate disposition of those who remain. What does that mean? Does that not mean that the people who remain might then be allowed something or other, right? Who knows, right? Who knows how far that door might open. So that's the MSNBC Lawrence O'Donnell approach. The other one, though, is this question of due process, which, given the attack on the First Amendment, we might want to look and see what's up with the Fifth Amendment. So the Fifth Amendment, the attack on the Fifth Amendment, I think it's clear. I said so yesterday. Moving forward, says Trump, we will issue detainers, not sure what that means, but detainers for illegal immigrants who are arrested for any crime whatsoever. Now notice it doesn't say convicted of any crime whatsoever, but rather arrested for any crime whatsoever. They will be placed into immediate removal proceedings if we even have to do that. In other words, maybe they're just, you're arrested and then you're in the cattle car. The Fifth Amendment does stipulate no person, not citizen, doesn't matter, any human being, no person can be deprived of life, liberty, or property without due process of law. That's by the federal government. The states, Sheriff Joe Arpaio, is forbidden to do that by the 14th Amendment. You see why they hate the 14th Amendment. Now, just a couple of positive things. Well, first of all, the most urgent. Congress is coming back next week. Yesterday in the Washington Post, I went through it on the other radio program, but we should mention it here. How Not to Fight the Zika Virus by Tom Frieden, the head of the NIH, and Anthony S. Fauci, who is our long-serving director of the National Institute of Allergy and Infectious Diseases at the National Institutes of Health. So Fauci and Frieden point to the fact that we've got 17,000 cases of Zika in this country, 2,700 on the mainland, a lot of them in Puerto Rico. Almost 1,600 pregnant women have been infected with the virus, and 17 babies have already been born with these crippling birth defects. The Obama administration asked for $2 billion. The Congress has done nothing, and they've used this as a vehicle. Instead of coming up with a clean bill, they put this stuff on there about Planned Parenthood and their other ideological shibboleths. So the CDC, the Centers for Disease Control, has had to transfer money out of HIV/AIDS programs, out of cancer programs, out of heart disease programs, and others to just stem the tide on Zika. That is robbing Peter to pay Paul. That's impossible. The work on vaccine is being slowed. The anti-mosquito work is being slowed. And this is a tremendous false economy. Every child, every baby born with microcephaly as a result of a Zika infection can cost the public between $1 million and $10 million. So it would be smart to fund this money now. So we've repeatedly called on Obama, use your constitutional power, call those congressmen back, wreck their vacation plans. We're sorry, but this is the life and health of all these babies. So they're hoping that Congress will step up to its responsibilities next week. Notice that one of the people involved in this is Pence, right? The vice presidential candidate. The other thing, good news, that the attempt of the state of North Carolina to use voter ID to prevent voting by minority groups, poor people, and others has been defeated definitively at the Supreme Court. So this election will be contested under more or less normal conditions. North Carolina had tried to impose an onerous voter ID requirement, expensive, reduce the number of early voting days, changed registration to make it harder to register, harming blacks who vote for the Democratic Party. So the Fourth Circuit in, I think in Richmond, they say that this is now Judge Diana Gribben-Motz, who I think provided a positive, a reasonable view of this. The new provisions target African Americans with almost surgical precision, and they impose cures for problems that do not exist. The state of North Carolina, with its asserted justifications, cannot and does not conceal the state's true motivation. Of course, the state says, we're afraid of voter fraud, and we say there's almost no such thing as voter fraud. Why don't you look at vote fraud? Why don't you investigate the ORCA system deployed by Karl Rove the last time around? So that was July 29th in the Fourth Circuit, and now it turned out to be a tie. Roberts, Kennedy, Thomas, and Alito say, go ahead, North Carolina, suppress the voting, but it's not enough. It's a tie. And therefore, the rightly argued, with right reason, the argued opinion of the Fourth Circuit stands, and North Carolina will not be able to suppress the black vote, as they had tried repeatedly to do. Now, that could be the whole election ball game right there. It's now time for the utmost vigilance. We've also we got all kinds of articles. We haven't had time to talk about them because of this First Amendment emergency developing around this program or my website. But it's going to be time now to look out for October surprise, and that involves Assange, who's now the one who has put his name on that. And we're going to be vigilant, and we'll be talking about that more this coming week. Go to americansystem.tv, americansystem.tv, and we'll be back here next week on World Crisis Radio. Thank you very much.